Hello, everyone. This is Navneet Sharma. We are here with a new episode of Competition Kaffeeklatsch. With me today, two eminent guests are Lauren O'Brien and John Ecklin. Both are from Linklaters, and the context of today's Kaffeeklatsch is the Legal Technical Outlook 2024, published by Linklaters. And thank you, Lauren and John, for agreeing to be our guests today.
Thank you for inviting us.
Let me introduce both the guests today. Lauren is a counsel in the Antitrust and Foreign Investment Group of Linklaters, and she's based in London and Brussels. She has wide-ranging experience across the EU, the UK, and the Irish competition and foreign investment matters, including merger control, foreign investment filings, behavioral competition matters, consumer law, and compliance. And I'm sure, Lauren, you have been busy in DMA, DSA, and related matters last 2 years. Firstly, in preparation of those, and then now enforcement. Welcome, Lauren.
Thank you, Navneet. It's great to be here.
John specializes in merger review process and a broad range of antitrust and regulatory issues related to cross-border mergers, acquisitions, joint ventures, and other business arrangements. John has a particular focus on complex global antitrust issues in innovative industries, including the technology, financial services, and pharmaceutical sectors. He has previously supported a variety of clients from Linklater's Beijing office, and he's intimately involved in the antitrust action in the United States. Welcome, John.
Thank you. Great to be here.
So what I propose today is let's first cover the tech mergers, because today the broad focus of our episode is to provide our audience a clearer, more comprehensible perspective of tech legal outlook in the year, how it is likely to unfold. So let me first pick up tech mergers. Let me ask first from the European perspective, Lauren, do you see a real risk of regulatory divergence in 2024 concerning merger scrutiny?
Yes, thanks, Navneet. I think there is a real risk, at least for some cases. And really just taking a step back, the root of all this is that there's been consensus, I think, among regulators for several years now that in the past 2 decades, merger control authorities around the world regularly got the difficult analysis in a merger context in digital markets in particular wrong. And they let many problematic mergers evade review or intervention. And kind of the poster child that's often used for that is Facebook's acquisition of Instagram, which was reviewed by the UK Competition and Markets Authority at the time and was cleared unconditionally. And so in response, in more recent years, authorities have been looking for ways to review and intervene in more tech deals. And while there's significant alignment among those different global regulators about the specific types of competitive harms that can arise in tech deals, there really remains outcome critical divergence on both substance and remedies. And we've seen that in the year just gone by in a number of cases. The big kind of ones to call out probably are 2023 proved fatal for Booking.com's attempted acquisition of eTravely. There's an appeal pending on that before the courts in Europe. The CMA had cleared that deal unconditionally in phase 1, but the European Commission blocked it. So we're seeing regulatory divergence there where it's difficult to predict where the regulators will go. And we're also seeing remedies divergence. And again, the big case that happened in the year just gone is the Microsoft Activision deal looked to be about to be derailed by the CMA, who prohibited the deal initially, before they made an unprecedented turnaround and cleared a new version of the deal. And so I think that risk of divergence is going to continue in 2024. But probably it's also worth putting things in perspective a bit, that regulators actually tend to agree on the vast majority of cases. But I think for some of these big kind of cutting edge cases with difficult theories of harm in tech markets, that's where we still will see a real risk of divergence.
Let me go to John and ask him, what are the new risks in the US? And do you concur with Lauren that there are risks emanating out of substantive and remedial part of the merger scrutiny? What do you see? What kind of outlook do you see in the US?
Great. So I agree that there is continuing risk for deals. On the substantive side, I think the agencies are more aligned, and you're seeing in practice quite a bit of coordination between the agencies, particularly the US and the UK. In the US, that is tempered to some extent by the courts in a way that administratively you don't see in some other jurisdictions where there may be more discretion afforded to the agencies. So you're seeing a process where the US enforcers are taking an enforcement decision that may be aligned with other jurisdictions, but may have difficulty in blocking the deal in court or in the FTC's administrative proceedings. So you're seeing some uncertainty, maybe not overall divergence in policy, but some divergence in the ultimate outcomes and some divergence in the timelines for achieving those outcomes. I think the biggest development in the US has been the release the end of last year of new merger guidelines, which really crystallize the agency's approach to digital markets in particular. I'd say they're largely aspirational. On one side, companies have been asking for clear rules of deals that are safe. The guidelines provide a lot more color on what the agencies view as presumptively harmful. So for large companies making transactions, you'll see the agencies trying to take a more aggressive approach on that front. They also encapsulate what the agency's been viewing in terms of new theories of harm, whether that is potential competition, nascent competition, or ecosystem theories involving platforms acquiring businesses that aren't strictly inputs or strictly competitors, but have a competitive effect. I think we'll see the agencies really looking for test cases in the next year or so to put those theories to work. And it'll be very interesting to see how those interplay with the approaches taken by other regulators.
And in terms of what's to come also in 2024, I think it's worth noting from kind of an EU and UK perspective, which I think we're going to talk a bit in a while about kind of platform regulation, but that also has a merger control kind of nexus, because there's now obligations kicking in on the largest platforms under the Digital Markets Act in Europe, and the equivalent that will come into force in the UK, the Digital Markets Competition and Consumer Bill. And that places obligations on the gatekeepers or the large tech platforms to inform the Commission and or the CMA about any of their planned acquisitions. So kind of any deals that might have flown under the radar previously, which is actually quite rare, I think, will no longer do so. And the Commission has already been notified of some acquisitions by the gatekeepers.
Right.
And
yeah.
And of course, speaking of EU and the US and the UK so far, obviously jurisdictions around the world are keenly focused on digital markets and applying similar considerations, both to global deals and to deals involving their own local champions. So I think there's potential for both convergence and divergence there. There are certainly jurisdictions like China, which have both very different market structures when it comes to tech and prioritize certain theories of harm, particularly, for example, ensuring security of supply for China for global deals, I think there you do see fairly significant potential for divergence that needs to be managed carefully. Maybe not entirely opposed to each other, but something that needs to be managed as local considerations.
Right. I see great potential for divergence as well. I see that loud and clear. And only this week I checked that if you check the recent past, I think a couple of mergers, perhaps 4 mergers, have been stopped in the US by the 2 agencies. So there is clearly they are in hyperaction mode, and everybody is very keen to see what kind of outcomes, particularly diverging outcomes, they will produce. And on an entirely unrelated note, John, I must mention that 2 days back, I saw an article by some MIT professors, and they were wondering if MIT would have merged with Harvard in 1904, what would have been the tech scenario in this side of the US. So anyways, that's on an entirely unrelated note.
Competition on lots of different components.
Absolutely. Let's come to the managing remedies part, because both of you are very good at that. So how can companies, how can corporations manage these risks which are looming large practically in every part of the world? Let's look at some ways, potential ways in which companies can manage or mitigate some of these risks you just mentioned.
Yeah, definitely. So I think it's become more difficult for companies, but there are strategies they can employ. And I really think parties to international tech mergers, often where markets can be global, but they need to consider how global competition concerns will impact national and regional markets, and how individual regulators will look at those. So I think in particular they need to have a detailed consideration of local market conditions, what are customers going to say, what are competitors going to say, and those may differ between jurisdictions, and that's really a must. Looking at how the Commission adopted a different approach from the CMA and Booking.com, for example, and we haven't had sight of the full decision, but you know, it from the outside it looks like the theories of harm were very similar, but they came to different views. Potentially they were getting different views from the market. We don't know that yet. And I think, you know, a traditional kind of one size fits all remedy package that we might have been used to previously in other industries, where you might have been able to align regulators around the world, might prove a forlorn hope in many tech cases involving digital markets, as we've seen. And so I think really to try to mitigate that risk, we're looking at prolonged pre-notification processes to try and get regulators comfortable with the substance of the case, and to try and potentially warm them up to a remedy earlier on in the process, to test their views on it and align them with other regulators. I think those remedy proposals are going to have to be flexible. We saw that to some extent in the Microsoft Activision deal, where a revised deal with a kind of a fix it first remedy was submitted to the CMA and ultimately approved. And that was different to what was agreed with the European Commission. And then I think kind of looking at staggered submissions to allow regulators to consider those packages in unison, and getting the timing of that right, taking into account the timetables of the different regulators, will go some way to reducing the risk. But I think, you know, those things will have to be strategized in detail early on, and also risk allocation. So looking at how you're going to allocate risk in the transaction documents, in terms of agreeing to kind of hell or high water type obligations, or break fees if things go wrong, will also be more and more important in the tech context.
Right. And John, can we slightly dive deeper into the remedies part? Because I remember in olden days, not much creativity was needed in carving or crafting remedies, but there's a lot which goes into crafting right remedies these days, from both the sides, from the authority side as well as from the party side. So can you take a deep dive and help us understand how can companies really do some useful magical work about remedies so that deals go through?
Sure. Yeah, and I would say that no jurisdiction is more hostile to remedies these days than the United States. The agencies, the DOJ in particular, has taken a very strong position that only a very strong structural remedy, divestiture remedy of an entire business is sufficient to address concerns. I think this, at the same time, there's a tension when you are moving into more novel theories of harm that aren't easily susceptible to structural remedies. And I think that is where you're seeing particular divergence in the European Union, which may be more open to administering behavioral remedies, supply commitments, access commitments, open offers, and the UK and the US, who are more opposed to it, although we've seen some signs from the FTC they may be more open to behavioral remedies to address their more novel concerns. I think when you're talking about structural remedies, divestitures, I think it's very important that companies think long and hard about what's in and what's out, what's really needed for the divestiture buyer to compete, who your divestiture buyer is, and making sure that you have the levers that you need if you do take a commercial approach to have a narrower remedy, to make sure that the levers are in place to have some flexibility, as Lauren said. And you need to be prepared to, in the US, increasingly parties are engaging in fix it first, taking a pre-baked remedy to the agency and then taking it to court and litigating the sufficiency of the remedy in court. I think in the US, if you have a complex deal that has potential divestitures, you really need to be prepared as a company to present a package, not just to the agency, but to a court to show its sufficiency. And we have seen a number of cases where parties have succeeded on the sufficiency of the remedy in court that wasn't accepted by the regulators in the first instance. Otherwise, I think you need to be very careful about understanding the local nuance in the different jurisdictions that you're approaching, and making sure that you don't blindly assume that an approach that works in the US or in Europe will work in every jurisdiction as well. I think we are very regularly seeing different types of remedies to address different local issues, whether that is supply commitments in China, to ensure that that critical inputs are still being supplied to the Chinese market, subject to restrictions in other jurisdictions. South Africa, of course, has very specific focus in merger review on social commitments to South Africa, making sure that you factor all of those into your policy and all the pieces work together from the beginning, so that you know what you're going into. You have a plan to make everything work, and you have a backup to defend that in the courts if needed.
Right. I mean, if I heard you right, John, what you're saying is that there's a lot of local context which can inform how you design the remedies, because different jurisdictions have vastly different local aspirations or macroeconomic goals, and mergers must fit in those goals. And therefore, companies need to be more watchful of the local aspirations and local macroeconomic priorities while crafting remedies. And that's
That's exactly right.
That's really an excellent insight you have offered to us. Let's switch gears and now come to the ex-ante regulation of digital platforms or digital economy at large, because the Brussels effect is all over, and EU's DMA model is being talked. Perhaps 2023 was the year when, if I can limit the universe of Google searches on competition law related terms, perhaps DMA could be very easily be the most searched term. That's my guess though, but I think so that most people were talking about it. But for lay people, Lauren, can you help us understand very briefly what is DMA, what is DSA, and how the two interface with each other? I think it will be good for our audience to first understand the fundamentals, and then we can get on to some of the outlook related issues in later part of our conversation. Lauren.
Yes, of course. Thanks, Navneet. And I think it's a really pertinent time to discuss this because, as you said, it's been top of people's minds for quite some time now. But we're currently actually at a really significant inflection point in terms of the EU regulation of digital markets. So after years of kind of policy forming, the European Commission is now switching to enforcement mode with the legislation in place. And so the DMA and the DSA were enacted by the Commission under one regulatory package. So that's why they're often talked about together. That's the Digital Services Act package. But they're actually separate and independent laws. And I think while there's a lot of commonality between them, as both of them aim to regulate digital markets and specifically online services and platforms, their scope is different. And that's because the DMA focuses on fostering competition in digital markets, focusing on those platforms or gatekeepers. Whereas the DSA is all about addressing concerns regarding the growing influence of online platforms in things like political discussions, disinformation campaigns, fake news dissemination, and hate speech. So really, it's aiming to foster or create a safer digital space where the DMA is aiming to promote competition. And so the DSA creates a system of tiered obligations for internet intermediaries. And that includes onerous new obligations for designated very large online platforms, or VLOPs for short, and very large online search engines. And then it's kind of in a similar vein, the DMA imposes wide-ranging new rules on what it calls gatekeepers. So those are online platforms with kind of significant and entrenched market power. And those are quite intrusive and in fact will entail some changes to their business models. And so the Commission has already started to ramp up, as I said. And so there are 19 VLOPs, very large online platforms designated now under the DSA. And the DSA has 6 gatekeepers so far. So 6 of the very large online platforms, and those cover 22 of what it calls core platform services. So you can have one gatekeeper, but they'll have a few of their services designated, for example, Google search and Gmail, etc. And so the DSA has already started to apply to the designated VLOPs. And for those designated under the DMA, there's really a huge compliance push already taking place, and that will continue to ramp up over the coming months when the obligations start to kick in March, which I think we might cover in a bit more detail.
Right. We'll come back to this, what happens after March, but for our audience in India, South Africa, or in Korea and Japan, let's say, for hypothetically speaking, if a DMA kind of law were to be implemented in any of these jurisdictions, what kind of compliances, what kind of restructuring, what kind of re-engineering the product or the processes? Because DMA clearly entails companies to undertake massive restructuring of the way their apps or websites are organized, how the information is harvested, cultivated, stored, and passed on. So there are massive compliances in a most generic format. Can you help our audience understand any digital platform, if it were to be designated as a gatekeeper, what will it entail? What will change in its life once it is designated as a gatekeeper?
Yeah, of course. So they will have compliance reporting obligations. to report on their compliance with the DMA to the European Commission, and they'll be subject to that on an ongoing basis. They'll also be subject to bring any acquisitions that they undertake to the Commission's attention, as we've previously discussed. And then there's some very broad and potentially quite intrusive obligations. Some of them relate to things like interoperability. So gatekeepers have to allow third-party services to interoperate with the gatekeeper's operating system. Others relate to kind of things like data access and usage. So there's a ban under the DMA, for example, on combining personal data across different sites of the gatekeeper without the end user's consent. So that kind of thing will entail the gatekeepers amending their business model in order to comply with the obligations under the DMA. There are obligations around the distribution and bundling of services. So one of the other obligations is a ban on preventing business users from offering the same products or services to end users via third-party intermediation or their own direct channels at different conditions or prices. So I think all of these kind of things are going to really impact the way the gatekeepers do business and mean they're going to have to change their model. And I suppose the interesting thing, which we might talk about in a bit more detail, is whether they will change their business model just within the EU to comply with the DMA, or maybe that will stretch beyond the EU's borders, particularly maybe to neighbouring countries or even further. And I think that's really going to be a kind of a commercial decision for the gatekeepers in weighing up the costs and benefits.
We'll come back to this, but let's first go back to where you left your earlier question, where EU is in implementation mode, and March is when March is a very significant regulatory event. So between March and rest of the year, what are the critical regulatory events do you see? Because that's very much part of your outlook. And audience would also like to understand how will it pan out in the EU and perhaps how it will inform even other jurisdictions.
Yeah, of course. So the key date for the DMA is the 6th of March. 2024, and that's when the DMA obligations will apply to the gatekeepers. So they've all been gearing up for this in the past few months, and those obligations will kick in on the 6th of March. On that date, also all the gatekeepers have to provide their first compliance report to the Commission, and they also have to produce a report for the Commission on consumer profiling, and that's under Article 15 of the DMA. So it's basically a report, an independently audited description of any techniques for profiling of consumers that the gatekeepers apply. And then I think they'll be subject to the obligations and monitoring on an ongoing basis. So at least every 3 years, the Commission will assess if the gatekeepers continue to meet the quantitative and qualitative requirements under the DMA. And if the core platform services that are subject to the DMA need to be amended. So that will likely change over time. And then every year, the Commission as well is going to examine whether new undertakings will satisfy the requirements for gatekeepers. So for example, Booking.com has actually said that they are likely to be designated in the next round of designations by the Commission. So there'll be a 7th gatekeeper potentially next year. And then for the DSA, just to touch on that for a moment, the key date there is the 17th of February 2024, when the majority of the DSA rules are going to kick in and apply. And I think we'll also see potentially, you know, there are a number of appeals ongoing of the designations under the DMA. So we'll see the results of those, and those are going to be quite interesting as well, I think, in informing in the scope of it and how the courts interpret it.
Right. Before I bring John in to give us slightly wider perspective, I still want to ask you, Lauren, because there's a lot which is happening in the UK as well, the DMCC bill. And what's your estimate when this bill is going to be enacted, and what kind of enforcement scenario do you see in 2024 in the UK?
Yeah, it's actually a very good time to discuss this as well, because the CMA has just published an update on this last week. So the DMCC bill, it went up to the House of Lords in the UK from the House of Commons in December 23. And this month, the House of Lords will have the committee stage where it's going to scrutinise the bill line by line. There have been proposals for a number of reforms to the text of the bill at the second reading in the House of Commons. It's not really clear yet which of those, if any, will get legs, but we don't think there are any significant changes really to be expected. And the current view is that the bill is going to get royal assent, so it will be enacted in the spring of this year. We think probably around Easter. So that's coming in a couple of months. And the CMA has been really gearing up for this for several years. It has the digital markets unit is up and running. I think they have about 200 staff. And so they're really ready for this coming down the tracks. And last week they published a roadmap on the DMCC and its proposed approach to the SMS, which is the strategic market status regime. And they confirmed there that they are really operating on the basis that they're going to get their powers in autumn of this year. So it's imminent, coming down the track. They've already said that they anticipate kicking off 3 to 4 SMS designations, which is similar to being designated as a gatekeeper under the DMA. This year, and those designations will take place around July 2025. So it's all happening in the UK as well, in parallel with what's going on in the EU.
But also, can you help us understand the key differences between DMA and DMCC? Top 2 or 3 differences which are really meaty and where the substance of the 2 laws really differs.
Yes, of course. I think there are 3 really key differences, and the overarching distinction is the UK regime within the DMU is inherently more tailored and flexible to individual firms and their activities. So the DMA in the EU has a kind of one-size-fits-all approach. It has quantitative thresholds. It's more rigid, but also that creates, from the perspective of tech firms, more legal certainty, you would say. So I think the first kind of key area of substantive difference is in relation to how firms are designated under the regimes. So there are similar qualitative tests that capture the largest kind of digital firms with those kind of entrenched market positions. So we think that similar firms will be designated under the regimes. But the DMA in the EU has quantitative thresholds, and those thresholds raise a rebuttable presumption of the qualitative thresholds being met. And the Commission can designate under those thresholds in 45 days. But the DMU in the UK doesn't have the same shortcut designation. It always must undertake a full investigation to designate firms as having this strategic market status, and that takes around 9 months. So it's much easier for the Commission to designate firms when you compare to the DMU and the CMA. I think the second limb to that is that the core platform services, as they're called in Europe, or the designated activities, as they're referred to under the DMU regime. So again, the DMA is more rigid there. It sets out a prescriptive list of 10 set core platform services, and they're specified in the legislation. There's some scope to amend those, but it's difficult to do so within the scope of the legislation. And it's worth noting that the current list doesn't include key areas that have come up in the digital space, such as AI. Whereas the DMU, again, has more flex there, because the concept of designated digital activities is inherently more flexible, and it gives the CMA more discretion to determine the scope of that. And then I think the third and last limb of substantive divergence relates to the substantive obligations. So the UK DMU has really, again, tailored rules that will be different for each firm and digital activity, and that's at the broad discretion of the CMA. So those rules are more flexible and malleable in the way they operate. Whereas again, the DMA has more of a one-size-fits-all approach, which is specified in the legislation. And again, they are in theory amendable, but it's more difficult to do so. So I think all in all, kind of the headline point is really the DMCC here in the UK gives the CMA's digital markets unit really considerable discretion and goes beyond the powers of the DMA in the EU.
So theoretically, at least, because we don't have any empirical or early evidence of enforcement from the UK, so therefore I'm saying theoretically, it looks like the DMCC is a plus version of DMA with some discretion, provided CMA can use it very discreetly, very wisely to carve out remedies and deliver better impact in the digital markets. Let me go to John now and ask him, um, um, particularly in the US, but also the rest of the world, what trends are you seeing, John, of this ex-ante kind of regulation? There are a variety of threads which are under discussion. So what's your take from the US and rest of the world about this thread of regulation, ex-ante regulation?
I'd say that the Brussels effect really is in effect, and you're seeing the types of theories of ex-ante regulation, or at least the types of harm and the considerations for fixing those perceived harms spilling into lots of jurisdictions. In the US, a couple of years ago, there had been some legislation introduced at the federal level that seemed at the time to have some bipartisan support across the political spectrum that would have not necessarily truly ex-ante regulation, but would have created enforcement rules that applied similar standards to some of the considerations in the DMA. Those have since largely stalled. And there's been some changes in approach in some of the different political elements that have shifted from supporting these types of initiatives to taking a more protectionist approach and suggesting that the agencies have been colluding with foreign agencies against American businesses, against the American platforms. I think those issues are still alive there's some state regulation, potential regulation that is still circulating, particularly around app stores, but is mainly coming through in enforcement and private litigation, challenging the types of theories of harm that we're seeing in the DMA and other ex-ante platform regulation. You also see a range of other approaches that are tailored to other jurisdictions around the world. I think China is an example of a jurisdiction that considered ex-ante regulation rules along the lines of Europe, has engaged in some enforcement, but today has shifted more to an informal regulation model, if to call it that. So there's much more informal engagement with individual platforms, discussion of their rules, and a back and forth on how to apply those rules in a way that satisfies the competition laws there, taking into account the very different market structure in China and the different players. You're seeing other approaches in other jurisdictions as well. I think South Africa is an example of a jurisdiction where they have taken a market study route, where they've done a large inquiry into online intermediation markets. The Competition Commission has now come across with recommendations for structural remedies to address market failures in some of the same markets that we're seeing in the focus of ex-ante regulation, and similar rules for online search, for example, for app store access fees, restrictions on links to third-party websites. Those types of issues there are coming across as a market study mechanism that has some ex-ante effects. You're also seeing more traditional lifting of the DMA model. Jurisdictions like Korea are reportedly focused on potentially launching a DMA equivalent quite quickly. Japan has elements of that coming out. And you're seeing other jurisdictions such as Australia, which were initially one of the leaders of focusing on ex-ante approaches or ex-ante solutions for digital market failures. There's just been some indication that in 2024 they may move ahead. The government may move ahead with some of the recommendations from the Australian Consumer and Competition Commission on codes of conduct for particular digital platforms. So it's really, I'd say there are variations on the theme where similar issues are being picked up in different structures that have varying degrees of enforcement and ex-ante regulation that achieve similar goals.
That's a pretty comprehensive global survey of regulatory approaches. Thanks, John, for that. Come back to US and give us a sense, because I see a good number of big tech antitrust cases being listed there and possible outcome expected out of those cases. So give us what do you see in 2024? What potential outcomes, what potential impact of those cases in the US and elsewhere? Over to you.
Sure. So I think in the US, the biggest news snuck in just at the end of 2023, beginning of 2024, when a jury returned a verdict against Google in the Epic private litigation challenging restrictions on Google's App Store. That has been followed in 2024 with Google announcing settlement with certain state attorneys general that would in effect open up certain aspects of the Android Google Play Store. And I think that's an area that's quickly developing, but is showing some fairly significant change coming out of a long-standing private litigation and state attorney general enforcement. So it's interesting to see that coming more to fruition. Obviously, there'll be appeals and various other aspects that could change the scope of what is actually being taken from that decision. So it'll be interesting to watch. I think antitrust enforcers have just delighted in watching the Google search trial, the DOJ's first case that has gone to trial among the digital enforcement cases. That wrapped up the end of the year. Everybody is waiting for the decision in that case, which I think will be very interesting in setting precedent on certain aspects of self-preferencing, how you apply the monopolization rules in the US to digital markets. So that's one that will have significant impact. And otherwise, there's a number of cases that are continuing through the fairly lengthy enforcement process, litigation process in the US. There's been some recent cases that have been announced by the agencies, the FTC's case against Amazon, which may go to initial decisions in court this year to test those theories. I think everybody's watching to see what additional enforcement will be launched by the DOJ and the FTC this year in the run-up to the US elections. So it's a very interesting time in the US. I think you're also still seeing you're still seeing enforcement and litigation in other jurisdictions as well, including new issues outside the DMA in Europe. So it's a very interesting time, and will be interesting to see how those impact conduct and whether there will also be knock-on effect from the ex-ante regulation.
I see it's a very important time and a lot of significant orders are expected this year. Let me come back to Lauren and ask her the replication of Brussels effect. I mean, what's your outlook? How many countries, how many jurisdictions are really going to adopt it with minor modifications? And how do you see this being replicated? Because countries have choices. I mean, John just explained how Australia, South Africa, Korea, Japan are considering a variety of approaches. But what do you see the potential of Brussels effect being replicated, Lauren?
Yeah, thanks, Navneet. I think it's a really interesting question and potentially requires a degree of kind of crystal ball gazing. But I think we see that the Brussels effect is definitely really significant in the digital sphere in particular. As the Commission has really been kind of a thought leader when it comes to this kind of ex-ante regulation of tech. Also influenced, I think, by the fact that the EU is such a big market, and therefore EU regulation may impact companies' business models beyond the EU's borders. I think John already mentioned some examples, but we're really seeing other jurisdictions and regulators following the EU's lead. There's implementing regulations in force in many member states for the DMA. Germany, of course, had a kind of a first mover advantage there with their platform regulation. And other global authorities, including, I think, John's already mentioned some, but Brazil and Australia are planning their own kind of versions of ex-ante regulation. I think it's going to be interesting to see whether other regulators kind of wait and see how companies respond to the DMA and how that plays out, and whether kind of the company's approach to complying with the regulation bleeds across to other jurisdictions, or whether they feel like they have to put in place their own ex-ante regulation in their own jurisdictions. And I think it would be really interesting to see that. And I mean, we've already discussed places like the UK where there's a similar but different approach being taken. So the regulator is giving itself scope to go beyond the EU and what the DMA is doing. So I think we've got a really interesting few years ahead of seeing how that's going to play out in practice, and the approach that the different regulators will take. And I think then, you know, another kind of arm to that is seeing how businesses react and whether they're going to change their business models by jurisdiction and adopt different ways of doing business. I think that's really going to be an interesting commercial jurisdiction for the big tech companies. Like, does it make economic sense for them to adopt the same approach outside the EU, potentially in kind of neighboring countries at least? Or will they adopt different approaches because it makes more commercial sense for them to do that? And so I also think that's going to be really interesting. I don't have the crystal ball view on that yet, but I think it's going to be a really interesting time, and there's really kind of a pretty complex matrix there for tech companies to consider in terms of how they do business across different regions.
No, that's very interesting perspective, how companies are going to react to these regulatory interventions. And there are potential outcomes of reorganizing their business models, reorganizing their products, processes, etc. I want to spend some more time on this and ask you, what are the preliminary outlook, preliminary trends you both of you are seeing in terms of response of companies? I see some anecdotal reporting in newspapers, etc., that companies considering a slightly tailored approach for EU because of the DMA compliances. Are we seeing a lot of fragmentation? What's your take? I mean, you watch companies very closely. So what is the outlook of the corporate response to this kind of regulatory interventions? And this is a common question to both of you.
I'd say on my side, we've had discussions with a number of companies that are considering how to implement these, as well as companies who are looking for opportunities in these areas. And I think the common theme is that there's no common theme in whether that is how broadly things are being adopted. I think there are certain, I think every obligation has a lot of implications, and it's really a technical, commercial, legal decision for each obligation to what extent you adopt it within the jurisdiction where the obligation takes place, a broader regional. So, for example, in Europe, within the UK, broader regions. And it really depends on range of factors, the technical implementation, how broadly the business operates. So is for data obligations, for example, is data already being used across jurisdictions? What are the restrictions? And what do they see as the regulatory risks in other jurisdictions? And what are the benefits for reducing regulatory risk in those jurisdictions by carrying across? So I think there are a number of factors that go into play. There will certainly be areas where implementation is localized, and I think that will be very interesting because it'll create a sort of natural experiment for regulators, enforcers, private litigants to see how the different approaches and jurisdictions play out for competition, and will be interesting to see where that how that is used, how that's analyzed going forward.
Lauren, you see some tailored approaches by some of these companies in the EU, what kind of products they're going to launch, new product launches, or reorganization of their existing products. Do you see some early trends?
Yeah, I think I mean I agree with John in that it's very hard to kind of trend spot because it's really not a one size fits all approach. It really depends on the specific obligation and the kind of the platform or the service that it applies to, and whether it makes commercial sense for companies to adopt the particular obligation in the EU and outside it. So I think it's a bit early potentially to trend spot because companies are still considering this and implementing the changes to their business models to comply with the obligations. I think like an interesting kind of comparator, because the jurisdictions are quite close and as we discussed the regimes are slightly different, is going to be, you know, whether companies adopt different approaches in the UK and the EU, given they're so kind of, you know, geographically close and linked. But I don't have any specific trends that we've identified at the moment. It's really kind of a case by case analysis for the companies on what makes the most commercial sense for them.
We've talked about regulators, we have talked about companies. We haven't really touched about consumers. So both of you can, and that's going to be my last question, because can you see in this whole process of regulatory entrepreneurial action and response by big tech, in this whole process, do you see consumers being better off or worse off? What's the outlook? What chances do you see this whole process, this whole churn is likely to yield?
I mean, I think the underlying aim of the legislation, both in the EU and the UK, is ultimately, you know, to give consumers more choice in terms of things like interoperability. I think again, it's going to be interesting to see whether that actually crystallizes once the legislation is in place for a while and the gatekeepers or the strategic market status firms are complying with their obligations. What's the real impact on consumers? And I think probably it's going to be a few years before we're able to kind of look at any empirical analysis on that. But it's certainly the aim of both pieces of legislation, and you would think that the net impact on consumers will be positive. I don't know, John, if you had a kind of a US perspective on that.
Yeah, I think that's right. I think in the first wave, certainly it's creating a lot of opportunity for smaller tech players, for startups. I think the hope is also in a lot of local jurisdictions, or the goal in a lot of other jurisdictions is to protect sort of local developers, local options to allow interoperability with the big global platforms, and distribution of content through big global platforms. I think there are meaningful criticisms, and I don't think they're just lip service, but there are criticisms from the platforms that this will reduce their ability to innovate, and that consumers will actually lose out on some of the potential functionality and innovative new products from the global platforms, to the extent that they require separation, to the extent that technical workarounds are required that prevent them from offering consolidated products using data across different services. So I think for consumers, there will certainly hopefully be more choice, but sort of if you look at the broader consumer effects, it'll be interesting to see. I'm not sure we'll ever know the answer of the but for, but I think there will be it will be a little bit more complex than some of the policy positions expect.
Thank you very much for your time and the insights you have offered.